So I've been following the rise and downfall of one of the largest, if not the largest, copyright enforcement. We call them copyright trolls, but they would disagree. They're just copyright enforcers, is what I think they would say. They were very aggressive. Malibu Media filed over 8,900 lawsuits. I think it was almost 9,000 federal district court lawsuits around the country. And I got my start as a copyright lawyer by being one of the first lawyers in the country to fight Malibu Media in court, in litigation, in a trial. I had filed motions to quash, which are objections to the subpoenas that they send to uncover internet subscribers' identities based on accusations of copyright infringement through BitTorrent happening on an internet connection. They don't know who the defendant is, so they subpoena the subscriber's identity and go from there. And I disagreed with that, so I would write objections to that on behalf of clients. And then one judge, Judge Michael Bailson of the Eastern District of Pennsylvania, ordered Malibu Media to take 5 of the objecting defendants to a trial type situation through litigation, through discovery of relevant evidence, and then see what happens. Because attorneys like me and me included were filing all these objections, is it true that they're copyright trolls, or are they just aggressively enforcing their copyrights? So the judge ordered 5 defendants to go through their trial. I represented one of the defendants in that trial, along with 4 other defendants and attorneys, and all 5 defense attorneys, including me, all worked together to write a combined motion to dismiss the case. We threw everything we could think of at it. We used all the court precedent that we could use, and the judge denied our motion to dismiss, and that was the beginning of the Malibu Media ascent. They would start filing thousands of lawsuits each year from 2013 or so until about 2016 or 17, maybe even into 2018. But around 18, 19, 20, they started fading away. They sued their first attorney, Keith Lipscomb. They got sued by their second attorney, second or third, Lori Lomnitzer. They got sued by their own investors, and there was a default judgment. I'll put a bubble about that one. And then we hear rumblings about how they're going to lose the Malibu beach house that they use to produce their films. And the latest salvo in the saga of the downfall of Malibu Media is John Doe's motion for an injunction, a preliminary injunction, freezing their assets. This is in San Antonio, Texas, the Western District of Texas. And defendant writes, they want an injunction barring Malibu from transferring or encumbering certain funds, and assert to protect Doe's likely award of attorney's fees and costs, including subscription fees from Xart, their website, any copyright settlement proceeds, the rights to any copyrights, the rights to any revenue-generating domain, including xart.com. Fair warning, that xart.com website is not work or child-friendly. John Doe has already shown a likelihood of success on the merits, which is one of the injunction requirements. Doe will suffer irreparable harm. He's incurred $80,000 in attorney's fees defending himself. Evidence shows Malibu and its single member, Colette Pelletier, who was a real estate agent, I think in Virginia or Pennsylvania, or maybe her husband was from Virginia. She started the Malibu Media effort with her husband, Brigham Field, I believe his name was. And they have a history of obscuring assets and ignoring judgments, says John Doe. John Doe argues the evidence shows Malibu and Pelletier are likely to hide away assets and ignore any money judgment. The case turns largely on Malibu suing Doe on what it knew was flawed evidence, as Doe shows in his summary judgment briefing. Malibu is a pass-through entity for Pellicier's personal enrichment. All along, Pellicer has been responsible for Malibu's endless filing of copyright infringement lawsuits. Pellicer created Malibu and runs it. She directs Malibu's copyright litigation efforts. So too does Pellicer treat Malibu as a pass-through entity. She admitted in a declaration from a breach of contract lawsuit, Malibu Media and Colette Productions are pass-through or disregarded entities who do not file their own taxes. There are therefore no corporate tax, I guess it's going on to say, records. Even though Malibu does business as Xart and offers its films over which it claims copyright on that website, current payments for subscriptions do not go to Malibu. By contrast, the subscription page shows that current payments go to Brigham Field, Pellicier's husband, through payment processor CC Bill. And a prior version of the page suggests payments went to ZoÄ Digital, one of Pellicier's many other LLCs, through a different payment processor, Epic. This all questions Pellicier's deposition testimony, insisting that everything is going to be funneled into Malibu Media. She has many LLCs used to conceal and mingle funds, says John Doe. Funneling Malibu subscription revenue to ZoÄ Digital is only a start. Pellicer is the sole member or manager for at least 7 other California and Nevada LLCs. There is Pellicier's testimony and other credible evidence from California cases showing that Pellicer not only mingles LLC funds with personal funds, but also transfers money to and from LLC accounts for personal expenses. When you have an LLC, in order to have the full benefits of the protection, the limited liability, literally in the name, you need to observe the corporate form, which means keeping separate money. The money from the LLC should be in an account under the LLC's name, and you shouldn't just be transferring personal funds into and out of each other's accounts. Malibu money should not be in Pellicier's personal accounts, and Pellicier's money should not be in Malibu's accounts. If the LLC owes the person personally, that's fine. That's called a disbursement or a distribution or a number of other things, depending upon what you're doing. But that's okay. You have to do it, and the formal transfer is fine. It's the keeping of the funds. It's if you have 50,000 LLC funds and you have 50,000 personal funds and you keep 100,000 in the Malibu account because it'll be harder for people to find it there. That's commingling funds, and that's not allowed if you want the LLC to work as intended with its liability limiting function. Pellicer has a history of ignoring judgments and other obligations, says John Doe. A California judge recently held Pellicer in contempt after she repeatedly disregarded her obligations in post-judgment discovery, even after the judge ordered her to produce financial information and sanctioned her over $18,000. And the evidence also suggests Pellicer and her husband have satisfied no judgments on their own. And the declaration says, I represent clients in other litigation with Colette Pellicer in which monetary sanctions and or attorney's fees have been awarded against her, Brigham Field, and their counsel of record, Murphy Rosen. Of the numerous awards against them in favor of my clients, only those awards that were ordered to be paid jointly and severally by Murphy Rosen have been satisfied to date. So it sounds like Colette and Brigham don't pay their judgments, according to this document. These track Malibu's former counsel suing it for unpaid fees, and of course Malibu failed to produce several key documents here, including communications with its infringement consultant. Malibu and Pellicer have several significant judgment debts, says John Doe. Pellicer has a significant judgment against her in California, and Malibu has at least 2 fee award judgments against it from other copyright infringement lawsuits. In addition, Colette's husband filed for bankruptcy in 2020. I did not know that. We learned something new today. So they're seeking an injunction, and they need 4 things. An injunction requires a substantial likelihood of success on the merits, a substantial threat of irreparable injury without the injunction. The threatened injury, if the injunction is denied, outweighs harm that will result if granted, and that the grant of the injunction will not disserve the public interest. Even though an injunction is not permissible to secure post-judgment legal relief in the form of damages, that's the definition of irreparable injury, is usually things that are not money damages. So if your reputation is going to be damaged and there's no amount of money that's going to repair your reputation, that's likely to be irreparable injury. We're talking about irreparable injuries, not injuries that can be repaired with money damages. The law does allow a district court to exercise its equitable powers, which are the powers of fairness, basically. When the law doesn't say if X happens, do Y, or the remedy is Y or Z or whatever. If the law says, yeah, we don't like it when people steal, but otherwise doesn't offer a remedy that solves the problem that's before the court can use its powers of fairness to make it right. And so when we say equitable powers, we're talking about the powers of the court to make things fair. The law does allow a district court to exercise its equitable powers in ordering a preliminary injunction to secure an equitable remedy. The court has authority to freeze a defendant's assets in anticipation of a possible future award of attorney's fees. These equitable remedies include attorney fee and cost awards, like those under the Copyright Act and other federal intellectual property laws. And so a court may enter an injunction freezing one party's assets to secure the other party's right to a fee award under the Copyright Act. Above all, an asset freeze injunction is particularly apt when the evidence shows that the fee debtor is likely to transfer or encumber assets that would otherwise pay the award. Doe is likely to succeed on the merits, says Doe. Doe proves in his summary judgment motion that Malibu has no evidence to create a fact question over non-infringement. Simply put, Malibu has nothing showing Doe downloaded or even accessed any of Malibu's films over BitTorrent, and so Doe is likely to prevail on both Malibu's copyright infringement claim and his non-infringement declaratory judgment counterclaim. These cases are kind of a shot in the dark. There are targets out there, and there are lots of pirates that could be hit by a shot in the dark, but you could also hit an innocent Doe. If Malibu sees infringement on an internet connection, they get the subscriber's name and address, and they usually sue the subscriber, but they're supposed to conduct an investigation and sue the infringer. Well, it's not entirely clear who the infringer is many times. You have information that at least on the preliminary level confirms that infringement occurred on the internet connection, but it's really hard to prove that that infringement actually occurred unless you also find evidence of the infringing activity behind the internet connection, the person, the computer, something else. And the law, at least as far as I've seen it, and I'm disappointed in the law and its execution in this area, allow the plaintiff to proceed with a case and attempt to prove their case. And when they don't prove their case, they're supposed to pay attorney's fees. So that's what this dispute is over, is it seems like John Doe is arguing that Malibu and Colette Pelissier and Brigham Field do not pay their judgments and attorney's fees award to the opposing party when they're wrong. They certainly enjoyed keeping the money when they were right, and when people settled or when they got judgments against defendants who may have actually committed the infringing activity. But when they get somebody who's innocent and they pursue that person accidentally or intentionally, even though that person isn't the actual, in fact, infringer, they're supposed to pay. And so it's kind of like being able to make a joke but not take a joke. Malibu is able to make the aggressive action but then doesn't want to pay for when their aggressive action is too aggressive and fails to establish a liable party. That is why Doe is also likely to win an award of prevailing party attorney's fees and full costs under the fee-shifting provisions. Though Malibu may argue fees and awards are not automatic, an award of attorney's fees in copyright cases is the rule rather than the exception and should be awarded routinely. And it is normal to award attorney's fees in a Malibu case. Even more, the applicable Fogarty factors from the Fogarty versus Fantasy case favor a significant attorney's fees and costs award to Doe. Those factors are frivolousness, motivation, objective unreasonableness. Remember, objective unreasonableness was a big one in the Carl Benjamin versus Aquila Hughes case. Her position was ruled to be objectively unreasonable, and Carl Benjamin got his attorney's fees award. Objective unreasonableness both in the factual and legal components of the case, and the need in particular circumstances to advance considerations of compensation and deterrence. So we also consider compensation and deterrence. As Doe has shown, Malibu sued Doe on evidence Malibu knew was flawed, and then it made no effort to develop its evidence or claims through fact or expert discovery, even though Malibu knew it needed expert testimony to prove BitTorrent copyright infringement. Nor did it turn over key discovery about IPP, the consultant Malibu used to generate the evidence on which Malibu sues Doe defendants. So they wouldn't turn over the evidence at all, according to this, which makes no sense. If you're going to sue people in a mass infringement suit scheme, you should have the evidence to back that up, or else that really is copyright trolling when you don't even have the evidence to go through with the proving of liability. That's probably sanctionable as well. These faults with Malibu's evidence and litigation conduct reveal a frivolous lawsuit lacking any objective reasonableness. So too does Malibu's failure to cooperate in discovery while making no effort to develop its claims show why a fee award fits the deterrence factor. Thus, a fee award is justified here. And they cite to a Malibu Media versus Mullins case where the Northern District of Illinois awarded attorney's fees against Malibu, having significant reservations about the frivolousness and reasonable nature of Malibu's infringement claim. What is more, Doe gave Malibu an opportunity for a walk-away settlement soon after Malibu sued Doe. And Doe warned Malibu that he would seek fees and costs should Malibu not accept. But Malibu chose to press its infringement claim to Doe's financial burden, and that is why the compensation factor also favors a fee award. Irreparable harm. To date, Doe has paid $67,465 in attorney's fees. That is sizable by any measure, let alone for an individual. It does not account for the $13,000 plus in taxable and non-taxable transcript and expert fees Doe has incurred. So this was the wall-street.com case, I think, where the Supreme Court fairly recently, in the past couple of years, ruled that you don't get all of your attorney's fees and costs back. Some of those costs are not taxable, as in, I'm not sure why they use the word taxable. They're not recoupable if you win a copyright case. Your attorney's fees are only recoupable for the attorney's fees for the case. Investigation fees are not recoupable. The expert witness fees are not recoupable. Travel fees, hotel fees, those things are not recoverable in an attorney's fees and costs award. Only attorney's fees related to the case, transcript fees, and court costs. I think there are three other categories, but they're all generally in that same vein. In short, Doe has a right to seek a significant fee award, but the evidence shows Malibu both will not obey any fee award judgment and B, will disperse and move revenue and assets that would otherwise go toward paying the fee award. Pellissier has testified that Malibu is merely a pass-through asset. Subscription payments are going directly to Pellissier's husband, Brigham Field, or another Pellissier LLC. Pellissier has let Malibu and her other LLCs go into suspended status. Pellissier takes funds from those LLCs to cover her personal expenses. She has a history of flouting court orders and rules, spurring one judge to hold her in contempt. Malibu and Pellissier have several other judgments against them, and Field recently filed for bankruptcy. This is all according to the document. All in all, this evidence reveals a sizable and imminent risk that Malibu will not pay any fee award to Doe. Pellissier will conceal or move Malibu's assets, or both. Malibu skirting any fee and cost award owed to Doe would cause Doe irreparable harm to his finances and his health. Lastly, there is no other adequate remedy for Doe to secure a fee award. Prejudgment attachment or similar relief is unavailable because, to Doe's knowledge, Malibu has no assets in Texas. And given the large personal judgments facing Pellisier, there is a real risk that she will raid Malibu's assets to either satisfy that judgment or conceal assets in another LLC, as the evidence reveals she has done before. An asset freeze will promote the public interest and the Copyright Act's purposes by ensuring copyright defendants like Doe recover from having to defend against unjustified infringement claims. So too will it deter other copyright holders who believe they can file baseless infringement claims only to cut and run when an adverse fee award is imminent. And finally, the balance of the fairness factors or equities shows an injunction is needed. As Doe shows, he will suffer irreparable harm without the court enjoining Malibu from casting off his assets. Malibu will suffer no prejudice from an injunction. It simply requires Malibu to retain assets for the pendency of this case. The only bond requirement should be for Malibu. So movant normally has to post a bond, and the court should not require a bond. So movant is this John Doe person, and so they're arguing that they shouldn't need to post a bond because I guess they feel that they have such a strong case. So they are asking for a $90,000 bond to lift an asset freeze. And that sounds pretty reasonable to me. If I was the judge, I would be reading through the case law and trying to figure out if that's an allowable remedy and then granting that remedy. But me personally and professionally, I'm very biased because I'm a defense attorney against Malibu Media, and I think what they've done with their 9,000 lawsuits over the past 8 years, I think that's pretty terrible and egregious. This is a company that, to my knowledge, and I've investigated these things, but maybe they changed something, they don't take any steps to warn pirates or potential defendants to give them a chance to stop. They don't send a cease and desist. They don't send a DMCA takedown. Again, that I'm aware of. Maybe they do send some DMCA takedowns, but most of the clients that call me never received a DMCA takedown at all, and none of them received a DMCA takedown for the plaintiff's material. So I don't think that they send DMCA takedowns. I don't think that they watermark their downloads. You know how iTunes watermarks your music downloads so that if you share your music files, they can trace it back to you. They don't do that on xart.com or any of the other sites that I'm aware of. In other words, this kind of lawsuit enforcement scheme, this copyright infringement enforcement scheme or method is flawed because it only goes after the users, the end user pirates, and not after the people who are supplying the initial seeder of the BitTorrent download. So I disagree with those methods. Just observing infringement on an internet connection and then making a federal lawsuit out of it, I don't believe that that's enough. The jurisdictional standard is to raise the pleading from an accusation that is merely possible into an accusation that is plausible. So in order for Malibu to sustain a lawsuit against a motion to dismiss, it should have raised the likelihood of the accused conduct from merely possible to plausible. Suing a subscriber or suing any one person behind an internet connection without any additional evidence connecting them, something more is the way courts have phrased it, that sounds only merely possible. It's merely possible that a defendant will be an actual infringer. Sure, it's a shot in the dark and there are lots of targets and you might hit a target. That's fine. I understand the connection there, but the pleading standard is plausible, that you're going to be able to accuse one person and that person is plausibly the infringer. And I don't think it meets that standard, but courts have said that it does. So I'm wrong, apparently, but I still disagree. That's what's happening with Malibu Media. That's the latest saga with Malibu Media, the latest episode in the saga of Malibu Media's downfall. I love watching it. I hope you do too. Let me know what you think in the comments below. And that's today's video. Special thanks to our top supporters in July: John Steele, Gavin Barnard, Eevi, Spirit Bear, Benjamin Hitov, Ugly Grill, Rudolph Bescherer Jr., Torpedan, Brandyn Abel, ShadowTycho, RDHDragon, Earthbound Star, and PureMagma. You can support Lawful Masses on patreon.com/ljfrench, sponsors.com/law, through YouTube memberships, and through Floatplane subscriptions. Join me for our weekly live production stream on twitch.tv/lawfulmasses on Sunday mornings at 10 a.m. Eastern US time. I hope everyone has a great week. I love you all. Bye.